Hi, it's Doug Isenberg, and welcome to the very first episode of what I plan to be an ongoing series of videos exploring important and interesting domain name dispute decisions, especially those under the UDRP, the Uniform Domain Name Dispute Resolution Policy. The first case I want to talk about today is one of the oldest UDRP decisions. It is actually only the fourth decision ever published by WIPO. It dates all the way back to February of 2000, but it is also one of the most important UDRP decisions ever published. It is still frequently referred to more than 20 years later, and it has been cited more than 6,000 times as precedent in WIPO UDRP decisions alone, as well as at other UDRP service providers. The case is Telstra versus Nuclear Marshmallows, and aside from an intriguing case name, I'll try to explain that in a minute, it is important because this was the decision that essentially created and established what is called the passive holding doctrine under the UDRP, which explains how a domain name registrant can act in bad faith if it is not actively using a domain name. Now, as you may know from my masterclass series of videos about domain name disputes, the UDRP requires a trademark owner to prove all three parts of an important test to get a domain name transferred. And one of those parts says that the trademark owner has to show that the disputed domain name was registered and is being used in bad faith. And the word "and" in that sentence is subtle but quite important because it refers to bad faith at two different points in time: when the domain name was registered and now. So the point is this: it's not good enough to show that a domain name was simply registered in bad faith. A trademark owner also has to show that it is being used in bad faith. And the UDRP includes four specific examples of how to establish bad faith, but it says nothing about inactive domain names. So the Telstra versus Nuclear Marshmallows decision was the first to address the issue of how to establish bad faith when a domain name is not currently being used at all. And here's what happened in the case. The UDRP complaint was filed by Telstra, which at the time of the decision in the year 2000, and maybe still today, I don't know, was the largest company listed on the Australian Stock Exchange and the largest provider of telecommunications services in Australia. Not only did Telstra hold more than 50 trademark registrations in Australia that consisted of or contained the word Telstra, but it also held trademark registrations in about 30 other countries or jurisdictions around the world for an extensive range of goods and services, actually covering 17 of the 42 trademark classes. And it held a number of domain names, of course, that included the trademark, including its primary website at Telstra.com. So someone using the name Nuclear Marshmallows came along and registered the domain name Telstra.org, which the decision says does not resolve to a website or other online presence. It's actually fascinating to read the decision in this UDRP case because it's unclear, as is true today, about the identities of domain name registrants in many UDRP cases, exactly who or what Nuclear Marshmallows was. The domain name registrant never formally responded to the UDRP complaint, and Telstra said that there were no company or business name registrations for Nuclear Marshmallows in Australia, even though the registrant used a post office box in New South Wales. So, as the decision says, the registrant's true identity could not be learned, which actually turned out to be pretty important as a factor in this case. So the UDRP panelists had no problem with the first two elements of the UDRP. But when it came time to analyze the bad faith element, that's where the decision got pretty interesting. The panelists pretty quickly was able to conclude that the domain name was registered in bad faith. But the reason that Telstra versus Nuclear Marshmallows is important is because of the decision's discussion of whether the inactive domain name was being used in bad faith. And here's what the panel wrote. The relevant issue is not whether the respondent is undertaking a positive action in bad faith in relation to the domain name, but instead whether in all the circumstances of the case, it can be said that the respondent is acting in bad faith. The distinction between undertaking a positive action in bad faith and acting in bad faith may seem a rather fine distinction, but it is an important one. The significance of the distinction is that the concept of a domain name being used in bad faith is not limited to positive action. Inaction is within the concept. That is to say, it is possible in certain circumstances for inactivity by the respondent to amount to the domain name being used in bad faith. And indeed, the UDRP panel ultimately found that Nuclear Marshmallows was acting in bad faith, referring to a number of circumstances that supported this conclusion, specifically that the Telstra trademark had a strong reputation and was widely known around the world, that the registrant of the domain name had provided no evidence of any actual or contemplated good faith use, that the registrant had taken actions to conceal its true identity, that it had provided false contact information when registering the domain name, and that it was simply not possible to conceive of any plausible actual or contemplated active use of the domain name by the respondent that would not be illegitimate. These so-called passive holding factors have since been recognized in the WIPO overview, which is a consensus document about the UDRP, and they are cited all the time in domain name disputes when there is no active use of a disputed domain name, which frequently happens. The passive holding doctrine created by the Telstra versus Nuclear Marshmallows case doesn't apply in every situation, but it's common enough that this has to be one of the most important UDRP cases ever decided. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing more UDRP cases. Thanks for watching, and see you next time online.